We'll get started.
We need to.
Welcome, everybody. Glad to see a room full of people. I'm Dee Ruggles, Dee Fairchild Ruggles. I'm the director of the Unit for Criticism and Interpretive Theory, and I want to welcome you to the Modern Critical Theory Lecture Series. And also just to say that we have masks here if you want to wear one. That's not obligatory, but it is recommended because rates are on the rise. My daughter has it, so now I'm really conscious of it. So we have masks if you want them. We also have the windows open. Air movement is good, right? And then I'd also like to begin with the land acknowledgement, a reminder that we are on the lands of the Peoria, Kaskaskia, Piankashaw, Wea, Miami, Pascutan, Ottawa, Sauk, Meskwaki, Kickapoo, Potawatomi, Ojibwe, and Chickasaw nations. Lands that were the traditional territory of Native nations prior to their forced removal, and the land continues to carry the stories of those nations and their struggles for survival and identity. As a land grant institution, and I always land on that fact, as a land grant institution, the University of Illinois has a particular responsibility to acknowledge the peoples of these lands, as well as the histories of dispossession that have allowed for the growth of this very institution. The two histories are not unconnected. Over the next 150 years, we will strive to become a vibrant community, inclusive of all our differences, with Native peoples at the core of our efforts. And before I proceed to introduce tonight's speaker, I would also like to remind you all that the MCT next week will be on the theme of waiting and the development of the spaces and protocols for waiting. And the speaker will be Helmut Puff, professor of history at the University of Michigan. Well, tonight we will have the pleasure of hearing the work of Mónica Jiménez, an assistant professor at UT Austin in African and African diaspora studies, with additional appointments to the Department of History, the Department of Mexican American and Latino Studies, and numerous centers. She is also somewhat unusual in that you also have a law degree, a JD. I don't think many of us have that kind of additional qualifications. And also unusual in that in addition to her scholarship, Mónica is a published poet. I just love that, from JD to poetry. For me, they seem like very contradictory sides of a person's curve. She has written numerous journal articles and book chapters on the subject of Puerto Rico, focusing on legal history, colonialism, political movements, and nation building, and also the forces counteracting nation building on the island, and race and diaspora. Her book, Making Never Never Land, Race and Law in the Creation of Puerto Rico, is forthcoming from the University of North Carolina Press in the coming year, in 2024. Her talk tonight is titled Toward a Legal Genealogy. You can just answer that phone or answer that child. Sure. Of racial exclusion, law, and the making of Puerto Rico. Please join me in welcoming Mónica Jiménez.
Sorry, I'm going to cough in this microphone. Thank you, Dee Dee. Thank you, Dee Dee, and for the invitation to speak with you all and to be a part of the Modern Critical Theory Lecture Series. I want to thank Jamie and Ty for organizing this visit and helping me get here, and to you all for being here and for taking the time and for your attention. And I want to say I have a little one, and I used to be in that position where I would take my little one wherever I was going, including poetry readings. And so for me, little ones are welcome. So he is a little boy, is very welcome. So thank you for coming, and thank you for bringing him. So I want to start, actually, since Dee Dee mentioned this, I actually had intended to do this anyway, but I'm glad that you mentioned it. I want to start with a poem. And I don't usually, oh wait, I said I would use this. Okay, I don't usually do this. I mean, I do read poems. I don't usually use QR codes. I am not a tech person. But I wanted to give you all the opportunity to follow along if you wanted to, which is also something I don't usually do because I think the poem should be heard and not. But this poem is annotated, and part of the sort of work of the poem is in the annotation. So if you would like to look at the poem and the annotation, I hope this QR code works. It works for me, but maybe, okay, good, perfect, thank you. Okay, so I'll start here with a poem called American State of Exception. 1. Sovereignty here does not bear its ordinary meaning. Nevertheless, it desires the power to punish. There is no authority when one lives on an island of indistinction. Necessity knows no law for those with need. What is the solution to the problem of colonialism? More colonialism. 2, consider this juridical conundrum. If the public powers violate the rights of the people, resistance to oppression is the duty of the citizen. Benjamin witnesses in spirit, pondering our legacy of natural law as a form of violence. There are certain principles of natural justice inherent in our character that need no expression in constitutions. 3, law functions to eliminate entire categories of people that do not exist and so cannot be integrated into the political system. Those who may live or must die, whose lives can be subjugated to the power of death. This is merely a question of legitimacy. Are you specifically authorized by the state to be a debtor? 4, justice finds that we are not a part of the political community brought into existence by our Constitution. This is the modern totalitarianism, a utopia devoid of law, a non-place where no violence is absolutely outside of the law. There is no legal succession in empire because the non-human cannot contract or capitalize. Everything is for sale in the frontier. 5, citizenship appears to offer us something other than exclusion. Still, we must be raced and we must be dangerous. Or we must be raced and we must be pitiable. Either way, we must first exist in bodies in want, as bodies in want of intervention. So I start here because I wrote this poem 6 or 7 years ago. In fact, I think, Jose, you read like the first draft of this years ago. And this was my way of getting into thinking about what would ultimately be the book that I'm publishing that's going to come out in May, hopefully, sometime in the spring. And it was my way of sort of thinking into the ideas that I had been kind of contemplating and trying to make sense out of a lot of different things, including this kind of legal, illogical legal sort of reasoning that I was encountering in US Supreme Court law. And oftentimes, that's my way into a thing, is through poetry, through art making as a way of sort of understanding something that I can't quite understand, just thinking in terms of the kind of theoretical or prose. And so this poem actually was published this month in a project called the Poetry Project newsletter. A friend of mine asked me to submit a poem with annotations for a special issue on dispossession. And I thought, oh, this is the one, right? Immediately I was like, this is the poem. And then I think it's fitting that this just came out and the book will come out soon. It's sort of a culmination of this thinking about what Puerto Rico is. So I want to start there because I think when the talk is sort of an expansion of all of this, right? The kind of ideas are here, and then the thinking grows from there. I want to start my clock because I want to make sure I don't go over time. Okay, so there was something else I was going to say about that. No, okay. So from there, what I want to do tonight is, I had initially thought, oh, I'm just going to talk about law and really think about the kind of that part of the book, which is the first half of the book that really sort of unpacks this legal history, this legal genealogy of exclusion and of exception. And then I decided, well, no, I kind of want to talk about the book, the larger book project, which really encompasses all of this anyway. It's not really, I can't really sort of extract one from the other, right? So I'm going to give you guys a kind of overview of the book with a focus on law and exception. So I begin here, and this is a quote from our late Supreme Court Justice Ruth Bader Ginsburg from March 2016 in the oral arguments of Puerto Rico v. Franklin, California Tax-Free Trust et al., a case which the opinion was handed down in June. So this is in March. A couple of months later, we get the opinion. But during oral argument, Ruth Bader Ginsburg says this. And the case was about Puerto Rico's attempt to pass its own bankruptcy law, basically, through a whole host of illogical, kind of unknown reasons. Puerto Rico was sort of excluded from the US tax bankruptcy code. but also excluded from passing its own bankruptcy law. So the territory tries to pass its own bankruptcy law. The banks that hold its debt, of course, sue, and it winds up before the Supreme Court. And Ruth Bader Ginsburg says, while she's sort of listening to the lawyers for the banks argue that Puerto Rico can't pass its own bankruptcy law, she says, why would Congress put Puerto Rico in this never, never land? Why in the world? What explains Congress wanting to put Puerto Rico in this anomalous position? And so this was in 2016, and I was following these cases closely and sort of trying to make sense of this moment in Puerto Rican history. And I read this, and I was like, what is she talking about? It's the Supreme Court that did this, right? The court of which she's a part. And surely she has to know this, right? So what is this theater about? The sort of outrage and the kind of, and that kind of sent me down this path of thinking. And to my kind of consideration, I felt like we were in this kind of parallel moment from 1901, when that Supreme Court case that first put Puerto Rico in Never Never Land occurs, to 2016, where we have Ruth Bader Ginsburg sort of, pondering what this weird position is. And I felt like those were legal bookends. Like we were sort of moving from 1901 and sort of finding ourselves in a similar moment. And that for me was really significant. And so I started to think about, well, what has happened in the sort of intervening century, right? What can we see? How do we see Downs, if we want to think about it as a kind of a ghostly figure? How do we see it sort of reappear and reappear and reappear? And that was really the question that motivated the book, was we're repeating this kind of logic again, and how has that impacted life in Puerto Rico, the possibilities of political futures, daily life, what people experience, right? What it is to be Puerto Rican. And that's where the book began, from a pretty simple seeming question, right? What is Puerto Rico to the US? What are Puerto Ricans to the US? But very complicated to answer or to contemplate. So what I found when I started to kind of think about this and think about what Downs was and how Downs was made, was that even though 1901 is this very important sort of watershed moment for Puerto Rico, the way that the court conceives of Downs, the way that it comes to that decision, has a very long history that precedes Downs, right? It precedes 1901. And it begins really with Native American dispossession and with the Piankashaw Indian tribe, in fact, and with a series of legal cases called the Marshall Trilogy. And it sort of proceeds through our Supreme Court jurisprudence in the moments when the US Supreme Court is sort of tasked with contemplating what do we do with these non-white folks who are on this land, right? And what do we do with people who are not sort of us, but who we have to contend with? And that was for me the way that I started to see these connections in this history. So when I talk about a legal genealogy, this is what I mean. I mean, looking back from Downs and looking at the cases that the Supreme Court itself cites, because it does cite the Marshall Trilogy, it also cites Dred Scott v. Sanford. Not just because those are cited within that case, but because those are sort of the most ignominious of our sort of legal cases that deal with non-white others, right, and racialized others. And so that was sort of the genesis for this. And what I began to see, hello, welcome. No worries. What I began to see and how I sort of began to understand this was that these cases, these Supreme Court decisions were creating these exceptional spaces, these spaces where either these groups were kept completely outside of the protections of law, or where law applied in a kind of piecemeal way, ambiguous way. And so from this I started to think about, okay, what are these spaces, what is allowed in these spaces? And so the title of this poem, American State of Exception, comes from that sort of thinking, right? These are states of exception that are being created through this constitutional law. And at the time, when I first started to think about this, I hadn't met Jose, and I didn't know, there weren't that many people who were thinking about Puerto Rico as a state of exception, or really thinking about what an American state of exception was, right? There was all this sort of discussion about Agamben's notion of the state of exception, the kind of the camp, right? Some discussion about the colony and the kind of very traditional like British colonial system, the plantation. And I started to think about, well, how do those legacies actually lead us to Puerto Rico? And what does that look like in a US context? So that's what I kind of came to in all of this, was that there exists this thing called the American state of exception, American entre comillas, as we say, right? Because America is not just the US, but when we refer to American, we often mean the US. And a US state of exception. And what does that look like? How does that sort of manifest in Puerto Rico, basically? So the overarching sort of theme is, let's look at these legal cases to sort of determine how this American state of exception is operating, and then what has that meant for Puerto Rico, right? So the first half of the book is really a legal history, and the second half of the book is, now let's look at Puerto Rico and in the 20th and into the 21st century. What has that meant here? And now that's a really long history, right? And you're like, what? Native law all the way to like 2023? That's a long time. But I do it in discrete sort of legal moments, and moments that I think are significant, and that offer us a way to sort of understand the operations of this. So it's not trying to be a sort of holistic, like I'm gonna cover absolutely everything that's ever happened in that intervening time in Puerto Rico. But it's really about these significant moments and the way that this is kind of manifesting. So what I wanna do with the rest of my time is just read to you some excerpts from the book and sort of contextualize some of this through these excerpts. And then hopefully that will sort of bring out some of this together. So let me see. I'm like, was I supposed to? No, I'm like, was I supposed to? I start to talk and then I forget the slides. Okay, so the steamer Ponce entered the port of New York carrying 576 boxes of oranges on November 20th, 1900. These oranges were the property of Samuel B. Downs, a merchant who was fast taking advantage of the commercial opportunities offered in Puerto Rico, the United States' newly acquired overseas territory. Upon arrival in New York, Downs's goods were intercepted and detained by George R. Bidwell, the collector of customs for the Port of New York. Bidwell designated the oranges foreign goods and levied $659 as import tax. Downs sued in federal court, arguing that since Puerto Rico had been acquired by the United States in 1898, it had become a part of the US, and thus taxation of goods from the archipelago was unconstitutional. This completely banal event, the arrival of tropical fruit from Puerto Rico at a port of the United States and the levying of import duties on that fruit, led to the most important legal precedent in the history of the archipelago, and one that continues to define Puerto Rico's economic and political possibilities over a century later. The case of Downs v. Bidwell, among the first of the infamous insular cases, which attempted to define the United States' legal relationship to its burgeoning overseas territories, was carefully followed by private business owners, legal scholars, politicians, the media, and the public at large. Downs and the other insular cases quickly became a referendum on the United States' imperial designs at the start of the 20th century. The US Supreme Court, understanding the many interests at stake, attempted to toe a careful line in which it could allow the US government to hold on to the insular territories and reap the economic benefits available therein, while also not extending citizenship or too many rights to the territories or their inhabitants. I focus on Downs v. Bidwell because it is there that the Supreme Court famously pronounced Puerto Rico to be foreign in a domestic sense, a nonsensical declaration that continues to flummox and confuse today. It was also in Downs that the court first declared Puerto Rico to be an unincorporated territory and set it on a course of legal exclusion that continues to define it today. The category of unincorporated territory, though novel at the time, had important precedents in the court's previous decisions dealing with Native and Black Americans. This moment of late 19th century imperial expansion forced the US to contend with the many mixed race inhabitants of its new territories. In the midst of Jim Crow segregation, the US government understood these subjects as decidedly non-white and more Black than not. Thus, the US turned to its history with its other non-white subjects for guidance on what to do with the people inhabiting the overseas territories. I connect Downs to the logics and legal reasoning of the Marshall Trilogy and Dred Scott v. Sanford, not only because both are cited by the court in that opinion, but also because the Supreme Court in Downs engaged in a critical moment of racial formation. It relied on its previous precedents concerning racial undesirables to make Puerto Rico a racialized space and its inhabitants intelligible within the racial and legal logics of the United States. This decision created Puerto Ricans as a racialized people and established the need to exclude them from the US polity. And I'll stop and say racialized in the US understanding, right? Racialization was already happening in Puerto Rico, right? But this was a sort of layering of US notions of race onto an already sort of existing notions of racialization. Within this legal genealogy, the Supreme Court carved out various states of exception, lacunae of law where the protections of the US Constitution do not apply or apply only in limited fashion, and where racial undesirables, like Native Americans, Black Americans, and the inhabitants of the insular territories, were left exposed to the whims and violence of the state. The court's decision in Downs created such a state of exception in Puerto Rico, wherein the US Constitution did not fully apply, and wherein the archipelago was left exposed to the vagaries of Congress's plenary or complete power. Collectively, the Marshall Trilogy, Dred Scott v. Sanford, and Downs form but a part of a much larger legal genealogy of racial exclusion that helped to illustrate how the court's reasoning, steeped in ideas of settler colonialism, anti-Blackness, and social Darwinism, underwent many contortions and legal gymnastics in order to create a space of exception for racial others. So I'll stop there and sort of talk through what Downs did and didn't do. So the question really, what was Puerto Rico to the United States, right? Now that the US had acquired this territory, what was it? Was it a part of the US? Was it not a part of the US? Were the people who lived there automatically citizens? Was it going to be a state? Did the Constitution apply, right? So the phrase that sort of pops up at this time is, does the Constitution follow the flag wherever the flag goes? It's not exactly how that went, but that was a sort of pertinent way of explaining to people the stakes of this question. So Justice Brown writes what we call a plurality opinion, which is to say that it is the decision that most of the outcome that most of the justices could get behind. But the legal reason for the outcome actually posed a lot of dissent. So even though he writes what becomes known as the kind of opinion of the court, it's not, there are several dissents and several concurrences that are sort of like, yeah, we agree with the outcome, but we actually disagree with the legal reasoning. And this is significant. So for his reasoning, we have this notion of Puerto Rico as a pertinent and belonging to the US, but not a part of the US within the US Constitution. That language of appurtenance was born in a series of a congressional act that allowed sort of adventurers to claim uninhabited islands for the United States. Really, literally, like if you think about like planting a flag for the US on an empty piece of land. There was this kind of race for guano at the end of the 19th century, and these guano islands were very, very lucrative. And so the US created this congressional act that allowed people to go out, and if you found an uninhabited piece of an island or a key or a cay or whatever, piece of rock that had guano on it and nobody else could claim it, you could claim it for the US. And it was then presumed to be appurtenant to the US. So that's where the language comes from. So at the time, the question of what appurtenant was kind of like, okay, people seemed to understand it. It was kind of ambiguous. But then it becomes important here, right? Because in the past, these islands were uninhabited. And appurtenance maybe it did have some sort of important implications, but when it comes to Puerto Rico, then it becomes even more important. So appurtenant to and belonging to the US, but not a part of the US. I always tell my students, I imagine this as kind of like Puerto Rico is like the sidecar to the US, kind of following it along, going on the ride, but not really directing it, right? Okay, and then it can nowhere be inferred that the territories were considered a part of the United States. The Constitution was created by the people of the United States as a union of states to be governed solely by representatives of the states, right? So a clear distinction between those people who live in the territories and those who live in the states. And the Constitution being sort of understood as being created for the states and its people, not for the territories. If those possessions, right, the territories, are inhabited by alien races differing from us in religion, custom, law, methods of taxation, and modes of thought, the administration of government and justice according to Anglo-Saxon principles may be for a time impossible. So again, There's this very clear sort of racialized understanding of the inhabitants of these territories as different and not us. And so we have to sort of allow Congress special dispensation to deal with those people in different ways, right? We don't have to follow the way that we've done things in the past, because this is a kind of, an extreme circumstance, an exceptional circumstance. And then finally, we disclaim any intention to hold that the inhabitants of these territories are subject to an unrestrained power on the part of Congress to deal with them upon the theory that they have no rights, which it is bound to respect. This is important, right? Because there was this very kind of real concern among the US public at the time that the US was becoming a colonial master in the image of Britain, right? Where it would sort of exercise a despotic power over the colonial subjects. And this was Justice Brown's sort of way of assuaging that concern, right? He doesn't say the Constitution protects those people, but he says, I am not giving Congress all the power to do what it wants. There are some restraints on power. He doesn't really enumerate what those restraints are. He says the people, the inhabitants of the territories have natural rights which all men are bound to respect. Again, he doesn't enumerate what those rights are, right? But they exist. There's also this great, I didn't include it, this great quote about the kind of natural, there's like a natural morality in people who make constitutions, and that will protect the inhabitants, right? So there's all this sort of idea that there's something inherently sort of just about US governance and congressional governance that will protect the inhabitants of the territories. But the Constitution itself is not gonna do it, right? Because that's not gonna go there. So this is Justice Brown. And again, this was the lead opinion. And then Justice White writes a concurring opinion where he agrees with the outcome. He has a differing idea. And this, he says, whilst in an international sense, Puerto Rico was not a foreign country since it was subject to the sovereignty of the US and was owned by the United States, it was foreign to the United States in a domestic sense because the island had not been incorporated into the United States, but was merely appurtenant thereto as a possession. This is where we get the unincorporated territory. So it's actually not in the leading opinion, it's in the concurring opinion. But at the time, and if some of you might have read the readings that I suggested, there is a reading about how we get to this opinion, which is that there are many legal scholars who sort of have ideas about what should happen. And there is a special journal of the Harvard Law Review that publishes 5 articles. And 2 of them are sort of like, yes, we can hold on to the territories. 2 of them say, no, we cannot. And then the third is called a third view. And that is the unincorporated territory. And this is the view that Justice White adopts in his concurrence. And eventually, over the next sort of 2 decades, the Supreme Court itself will sort of move towards this idea. And this will become the kind of the Supreme Court precedent. Like by 1922, when there's this like the kind of end of what we call the initial insular cases period, this is the logic that the court points to as the reason that Puerto Rico can be excluded. It's because it's an unincorporated territory, which it remains today. Okay, I keep wanting to be like questions because that's what I would do if I was teaching this to my students, but we'll wait. Okay, so from there, we start in 1901, we start in this moment, but it's clear, especially when you read Downs, that in fact we have to go further back, right? To really understand this moment. In history, in legal history, and the legal reasoning, you gotta go back. And so that's what I do in the book. I begin with Puerto Rico because you have to start a book about Puerto Rico with Puerto Rico. But then I go back in time to sort of take apart how we get Downs. So I'm going to read a little bit more from the book. In the early 19th century was a period of radical transition in the United States. As the growing population moved south and west from the northeastern region of the US, it became fractured. The question of sovereignty loomed over this period, animating disagreements about the powers granted to the states and those to the federal government. Against the backdrop of these intense debates in the first few decades of the 19th century, the US Supreme Court was also carving out a role for itself. During this time of sectionalism, many in the southern states did not believe the court had the power to review their decisions, given that they were separate sovereigns. This power struggle was most visible in 2 areas of wide important consequence: the abolition of slavery, and the so-called Indian problem. To be sure, the ignominious history of the US government's treatment of Native Americans and the enslaved is well documented. However, I'd like to revisit several key Supreme Court decisions concerning the rights of Native Americans and enslaved Africans and their descendants and the events that led to them. These precedents, which allowed for the dispossession of Native tribes, sanctioned the genocidal violence visited upon them, and subjugated enslaved and free blacks, are essential to understanding the Downs decision and the court's approach to Puerto Rico. And focusing on the Marshall Trilogy, which was decided between 1823 and 1832, and Dred Scott v. Sanford from 1856, we can see the birth and growth of plenary power and the American state of exception. Native Americans and enslaved Africans were among the first non-white others the US legal system had to contend with, and the precedents established in these encounters have had lasting legacies that continue today. As white settlers moved into territories previously occupied by Native nations, the Indian question remained ever present, namely, what was to be done with them? The imperative to civilize and to put land into productive use was one shared across sectors of the US population, but the matter of what to do with the Native people who resided on those lands remained unresolved. There was a great disagreement about whether Native nations should be allowed to remain on their land, whether they should be forced to sell those lands to the government, whether the US should employ the military to forcibly eject Native Americans from desirable land. The majority of opinions about what should be done were couched in the racist and paternalistic assumptions of the day. The Native Americans were either fierce warriors who had to be restrained or simple children who needed to be educated and trained. It is against this backdrop of debate and contention over where power should reside in the young United States that the Marshall Trilogy was decided. Native American exclusion, like that of Puerto Rico, is premised on Congress's plenary power. By the time the US acquired Puerto Rico in 1898, the court had affirmed Congress's plenary power over Native Americans on multiple occasions. Importantly, the court had also established that Congress's actions over Native Americans and their territory were not subject to judicial review, and as a result, that power was nearly absolute. Congress's plenary power over Native tribes was first established in a series of Supreme Court cases that began in 1823, known as the Marshall Trilogy, because they were decided under the stewardship of Chief Justice John Marshall. The ideas and doctrines enumerated in the Marshall Trilogy form the bedrock of Indian law. In these decisions, the court rooted the power over Indian affairs and Indian lands firmly in the national government, providing fuel for westward expansion and its radical transformation of the US landscape, geography, and the lives of thousands of Native Americans. In these decisions, we see the Supreme Court and US government carving out legal lacunae in order to assert a nearly unrestrained power over Native tribes, while also limiting their rights and access to legal remedies. As Professor Maggie Blackhawk describes, these decisions quite literally allowed for the creation of reservations and camps where Native Americans were confined, neglected, and violated. Here we see the birth of the American state of exception, locations of Congress's unrestrained power wherein residents are left with limited rights and few remedies. Plenary power has been expanded beyond Indian country to justify seemingly limitless power of all kinds of people at the margins of American empire. This, we know, is the case in the US colonial rule over Puerto Rico and the other insular territories. So I want to stop for a minute and talk briefly about what the Marshall Trilogy was. Johnson v. McIntosh, this first case, was born out of a dispute over territory in the Illinois territory, land in the Illinois territory. And the question was really, it's actually a really great case, and the history of it is bonkers. So if you ever get a chance to read it because it's wild. But the question ultimately was, could Native Americans sell their lands to private individuals, or were they only allowed to sell it to the US government, basically? And the question of what sort of possession Native Americans had over their land, right? So basically this is the moment where the court decides natives have sort of usury rights over land, but they don't have full sovereignty over their land. And if they're gonna alienate their land, then they can only alienate to the United States government. Famously, Marshall says that to leave Native Americans in possession of land would be to leave the country a wilderness, right? Because natives are incapable of properly stewarding the land. So this is the first of these cases. The second two are born out of disputes between the federal government and Georgia. Famously, Georgia's sort of history of seeking to expel the Cherokee Nation from within the state bounds, and passing all sorts of laws to basically dispossess the Cherokee, even though the Cherokee had treaties with the federal government, right, that actually were superior to the state laws, right? But this was Georgia's push and challenging the federal government and really challenging the power of the Supreme Court, right? So there's this kind of notion at this time, this real disagreement about where sovereignty lies, how much sovereignty the states have, what kind of sovereignty they have, what kind of sovereignty the federal government has, the role of the Supreme Court in reviewing and sort of deciding on the actions of states. And Georgia famously declined to participate in any of these disputes. So the disputes were brought, and Georgia was like, no, if we participate, then we're legitimating the court, and we're not going to legitimate the court, and so we're not going to participate at all. But so I won't go into the details of these two disputes, but what we can take away is that collectively these three cases stood for Congress's sort of plenary power and the kind of boundless plenary power over Native nations. And of course, plenary power then sort of becomes, through the Territories Clause, is the justification for federal power and federal governance of Puerto Rico. Okay, so I'm going to jump ahead a little bit. You know what? I might actually, in terms of time, I might actually just talk to you guys about law. We may not talk about the second half of the book at all, which is what I thought in the first place, so we're good. Okay, so following the Marshall Trilogy, the court continued to grapple with the status of racial others within the U.S. body politic. In 1856, in what has come to be known as the most disgraceful decision of the United States Supreme Court, Chief Justice Roger Taney wrote that blacks, quote, had for more than a century before been regarded as being of an inferior order and altogether unfit to associate with the white race, either in a social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro must justly and awfully be reduced to slavery. The court further explained that when the Constitution of the United States was created, it applied to all class of person who were recognized as citizens at the time of its creation, quote, but none other. It was formed by them and for them and their posterity, but for no one else. These pronouncements were, of course, part of the Supreme Court's infamous decision in 1856 in the case of Dred Scott v. Sanford, and would later be echoed in Downs to justify Puerto Rico's exclusion from the protections of the U.S. Constitution. The legal ramifications of Dred Scott would be overturned by several important pieces of legislation following the United States Civil War, the 13th and 14th Amendment, and the Civil Rights Act of 1866. However, Taney's pronouncements in Dred Scott remain important today, not only as illustrative of the racial animus and hatred that underpinned the workings of U.S. government at the time, but also as illustrative of the continued development and deployment of an American state of exception. Furthermore, the court's pronouncements in Dred Scott with regard to the concept of territoriality and the limits of the U.S. Constitution were instructive to the Downs Court in 1901. Taney's ideas with respect to the limits of citizenship and the role of race in deciding that citizenship also play a definitive role in that latter case. In Dred Scott, Taney created a category for blacks outside of the legal order. He rationalized that this group could be maintained as something other than citizens without any legal protections or rights. The same scenario which had played out in the Marshall Trilogy would be echoed 44 years later in the Insular Territories. And there too, the logic would be steeped in racist ideas as to the superiority of the white race and the inferiority of the mixed race residents of the Insular Territories. Finally, and perhaps most importantly, the court itself affirmed that a state of exception existed with respect to Afro-descended inhabitants of the United States. Taney's declarations that blacks had no rights which the white man was bound to respect marked them as rightsless individuals whose bodies were available to the balance of the state. If Afro-descendants in the US were not people under the Constitution, then they could claim no rights or privileges under that most revered document and were instead left to exist in the American state of exception. I want to stop there and think about Dred Scott v. Sanford. So we know this case mostly for its pronouncements on the status of Black Americans, right? Or not Black Americans at the time, but of enslaved people and free blacks. And we learn it in particular in terms of its pronouncements on citizenship and the extension of the Constitution, the protections of the Constitution. There's a whole nother discussion that we often don't learn, which is about the territories. And that, to me, is for our purposes in Downs, the most instructive part. Because here, what Taney says is that at the time, there's a common sense that everybody understood to be true, which was that when the US acquired territory, the Constitution and the Bill of Rights followed the US into the territories. And that territory was not acquired to be held indefinitely, but was acquired to be put on a path to statehood, right? And so this was the kind of, the doctrine of territorial expansion, I think it's referred to as, right? The way that the US, and this is him sort of looking back at how territorial expansion had happened, and sort of describing what was kind of common sense from how we had done this in the past, right? How westward expansion basically had happened. And so if we think about the Dred Scott is overturned by these acts of the Constitutional Amendment and the Civil Rights Act, but this part on the territories is not overturned. It's still in effect until Downs. So Downs, in effect, overturns the second half of Dred Scott, which we rarely talk about because it's not the most sort of salient, right? So before 1901 and Downs, the idea that you could acquire territory, keep it indefinitely as a colony, leave the people who inhabited that territory without rights indefinitely was sort of unheard of, right? It was not how we had sort of moved through westward expansion. It matters who lives in the territories, right? So when we were sort of expanding westward, right, the idea was that it was a lot of open space. It was empty except for these, bands of natives who were kind of spread around. And we already saw what we do with the natives, right? Like how the court treats natives. So that if there's this sort of lacuna that's been created for Native Americans who live in these territories, the presumption is then everyone else would be white, right, over time. And so of course we would apply the Bill of Rights to these folks. And of course we would apply the Constitution to those folks. We wouldn't want to leave white settlers without rights. But when you come in 1901, then you have a very different situation. So then you have to come up with different ways of dealing with the inhabitants of the territories. And that was the kind of legal fiction that foreign and domestic sense or unincorporated territory was meant to address. So I think I've been going for like 30 minutes. I don't know, should I keep going? I don't know what. I feel like sometimes when you're like, oh, you should lecture for 50 minutes. I'm like, I also don't want to bore people for 15 minutes. So if you guys are still with me, I'll keep going. Otherwise, I'll do questions. Okay, so part 2 of this book then is titled American State of Exception, Puerto Rico in the 20th and 21st Century. And it's really thinking about what does it look like? What does this American State of Exception look like in Puerto Rico? And I'll just talk you through this. I won't read. So then I spend a chapter of the book talking about the first 3 decades of Puerto Rico's like U.S. rule in Puerto Rico, which is a period of radical transformation in Puerto Rico. Right? It's a moment where society, the economy, education, health, like everything is reoriented. And I argue that there are competing reasons for this reorientation. One, there is this kind of benign colonial impulse, right, of like we have to sort of create better systems for these people. We have to teach them how to eat properly, right? They don't eat right, so we have to bring like U.S. like food cultures, literally, right, like milk and dairy farms and all these things that like had existed but weren't widely consumed. Cheese. So that right, there's this kind of like social hygiene project, right? And I am blanking on the name, but the impulse is sort of mosquito eradication, health measures, right? There's this total reorientation with a view to sort of help the poor Puerto Ricans who live there, right? And this is documented. This is not me sort of being like, oh, this is the kind of impulse, right? No, if you read some of the documents, like newspapers, congressional record, right? The rhetoric is one of, these are people in need of intervention, right? They don't know how to do for themselves. They're illiterate, they're uneducated. We have to help them, right? That's the kind of white man's burden attitude. So that exists. And right alongside that is this is an island full of people that we could put to work. And they can be put to work in service of US capitalist empire, right? And so very quickly, and as we see in Downs, right, Downs is a merchant. He's very, very quickly after the US's acquisition of Puerto Rico and the other territories, there are a whole host of entrepreneurs who are like, how do we make money here? And let's figure it out. And part of what develops with the help of the US government is a kind of consolidation of land away from cultivation of coffee, which had been the primary export crop, to sugar, and the consolidation of land in the hands of a very few corporations. And so like a reorientation completely of Puerto Rican society, and what I call the kind of creation of Puerto Rico as an experimental station, where literally experiments in agriculture, in social hygiene, in education, all sorts of different types of kind of experimental technologies. Famously, birth control, right, is tested in Puerto Rico. And this is during these sort of early decades that all of this is happening. And I argue that it's allowed, it can happen because of what Downs creates, right? Downs creates the space where the Constitution doesn't apply, right? And Congress has plenary power. Doesn't mean that the people in Puerto Rico are completely without recourse, right? Then there are many legal cases that challenge that try to nuance what does Downs mean, right? That ask the court, well, okay, Downs said the Constitution doesn't apply, but it said natural rights, so are these natural rights? Are we allowed this? Are we US citizens, right? So there's all these sorts of ways that people are sort of pushing back, as well as protesting, right? There's lots of protests that happen at this time. So it's not that Puerto Ricans are sort of passively accepting this, but for my kind of interest in this story is what is the project that develops, right? What is the colonial project that develops, and how does Downs allow that colonial project to develop? And so that's part of the book project, is really thinking about what does Downs allow in Puerto Rico that might not be allowed in the US? Or sometimes how does that mirror the way that the US treats African Americans in the US during this time period? I love kids' laughter, especially at that age. I miss that age. My kid's 8, so she doesn't laugh like that anymore. So then, of course, we have this very significant moment in the mid-20th century, right? We have the creation of the Estado Libre Asociado de Puerto Rico, the Commonwealth of Puerto Rico, the ELA, right? Which is the current status of Puerto Rico is that it's a Commonwealth of the United States. And so this moment in the 20th century, in the mid-20th century, was this kind of very ambiguous moment where at the time, there were arguments that creating this status for Puerto Rico was moving it out of a traditional colonial status. That the Commonwealth of Puerto Rico was creating local sovereignty. And that the territory was moving out from Congress's plenary power. Right? That was the rhetoric of the time. That was the public rhetoric at the time, I'll say, right? This is what the sort of the public was seeing in Puerto Rico and in the US. But really, when I approached this, my question was, what, if anything, did the Commonwealth of Puerto Rico do to shift Puerto Rico's and the US's relationship? What did Puerto Ricans think they were getting? What did Congress believe it was giving, right? And I love this quote from Rexford Tugwell, who was the last US appointed governor, but also one of the most progressive governors of Puerto Rico. In his memoir called The Stricken Land, it's all about his time in Puerto Rico and administering Puerto Rico. He says, Luis Muñoz Marin, who then later becomes the first elected governor of Puerto Rico, and serves for 16 years and is sort of credited with creating the Commonwealth of Puerto Rico. He says, Muñoz has fallen into the error of all insular politicians. He forgot the political victory in Puerto Rico was a matter of no interest to continentals, which, is pretty, I think is pretty sort of emblematic of the way that Puerto Rico sort of politicians or the politics of Puerto Rico and the way it's evolved, right? That of course, because it's a small place and everything seems very immediate and important, right? But then it's just ignored by the US, right? And it has been for a century and more. So these are quotes from Antonio Fernández Isern and Luis Muñoz Marín, two of the sort of architects of the Commonwealth of Puerto Rico, two of the sort of politicians who were most involved in making it happen and lobbying Congress and sort of talking to politicians in the US about Public Law 600, which is the law that creates the Commonwealth of Puerto Rico. So Public Law 600 allowed Puerto Ricans to draft their own constitution. And the constitution, the sort of enacting of the constitution, is what created the Commonwealth of Puerto Rico. And so Public Law 600 had to be approved by Congress, right? Congress had to basically give Puerto Rico permission to create its own constitution. And when the lobbying has happened, of course, Congress, congressional representatives are calling both of these men to committee and asking them, what does this really mean? Like, what is this document creating? What are the changes? And there are moments where sort of US politicians are like, well, but Congress is still in control here, right? Like, it's not Puerto Rico. And so these are some of the responses, right? This is Fernández Isern's response. Public Law 600 would not change the status of the island relative to the United States. It would not alter the powers of sovereignty acquired by the United States under the terms of the Treaty of Paris. And then Luis Muñoz Marín before the House. If the people of Puerto Rico should go crazy, and I love this quote, this is just wild, Congress can always get around and legislate again. I am confident that the Puerto Ricans will not do that, go crazy, and invite congressional legislation that would take back something that was given to the people of Puerto Rico as good American citizens. Right, so this is him sort of assuaging Congress's concerns that, you know, if we pass this law, Puerto Rico is going to govern itself and have power over itself, and you're displacing Congress, right? Which in some way is the rhetoric, right? The like, what they're telling the Puerto Rican people is, no, this is gonna give us sovereignty. Like, Congress will no longer be able to unilaterally act in Puerto Rico. While at the same time, they're before Congress saying, no, you don't have to worry. You know, it's not really gonna displace Congress. Like, you know, it's just gonna sort of allow us to have local say. So what the Commonwealth did was create a local government. Created the possibility of Puerto Ricans democratically electing their own governor and having democratically elected local officials and basically governing anything that was local. The problem with this is that Puerto Rico is an insular territory, right? So it's an island. So more and more over the last 60 plus years, we've seen that actions taken by Puerto Rico have a federal dimension, i.e., not local dimension, right? So that federal power was, over the course of this time, was sort of spread and has taken over more and more of the local in Puerto Rico. So that the question of really what was local and what was federal was always very blurry and has become, to my mind, a fallacy, right? There is truly nothing that's truly local in Puerto Rico, especially not after 2016, which takes us back to the bookend, right? The way I sort of start thinking about this is, what is happening in 2016? And what is happening in 2016 is very, very complicated. I don't have a whole lot of time, so I don't want to get too deep into the weeds of this, but we can talk about it in the Q&A if you would like. But most of us have probably paid attention to the last decade of Puerto Rico history because it's been very public, and a very public debt crisis, a very public series of crises, government-created, government-enhanced environmental crises. And so where we began in 2016 was with this case, Ruth Bader Ginsburg. And at the time, when Puerto Rico's governor in 2015 says this debt is unpayable, and the debt is massive and it cannot be paid, it sort of sets a series of events into play, one of which was Puerto Rico's attempt to pass its own bankruptcy law, which wound up before the Supreme Court. And a lot of lobbying on the part of Puerto Rican politicians and Puerto Rican sort of well-known Puerto Ricans before Congress, for Congress to do something to address this debt crisis, right? There was also a lot of fear-mongering on the part of the banks that own the debt, right, being sort of putting out these ads that were really the scare tactics, like, oh, I remember seeing them. I was living in Chicago, and I remember seeing them on TV in Chicago. And it was like, oh, Congress is going to bail out Puerto Rico on your taxpayer dollars. Like, don't let Congress bail out Puerto Rico. And there was like this one that was like, you know, Puerto Ricans have been like irresponsibly living on the high on the hog on your money, right? It was just like these terrible like scaremongering ads to dissuade, right, to compel people who knew very little about Puerto Rico to reach out to their representatives and be like, hey, don't bail out Puerto Rico. Like, that's our money, right? Taxpayer money should not go to those folks. And it worked. It worked. And so instead of whatever, you know, might have happened, bailout might have happened, which I don't think that was ever actually on the table, we got the Puerto Rico Oversight Management Economic Stability Act, PROMESA, which is still in place. And so this moment in 2016, where the Supreme Court decides these two cases, and this other case, Sanchez Valle, is a criminal law case about Puerto Rico's power to prosecute in the face of federal prosecution. So it was a double jeopardy case. Could Puerto Rico prosecute an individual for the same crimes that the federal government had prosecuted him for? And Puerto Rico argued, of course we can. We're a separate sovereign, and the Fifth Amendment allows for that to happen, right? Two sovereigns can prosecute a person for the same crimes. And the Supreme Court, and this is very significant, said you're not a separate sovereign. And not only are you not a separate sovereign, but most significant, the power that you have to prosecute crime is a delegation of congressional power. So your ability, your constitution, and everything that stems from your constitution is a delegation of congressional power. Congress is the ultimate source of your power. So again, right, the most sort of fundamental local prerogatives prosecuting crimes, if we were talking about this other case, addressing its sort of financial situations, are not local, right? They're federal because they come from Congress. And so they're actually not within Puerto Rico's purview. So this 2016, and this all happened in June, by the way. June was like a sledgehammer blow to Puerto Rico. All three of those sort of events combined made it very clear to people in Puerto Rico that whatever the Commonwealth was, whatever was created when the Commonwealth was created in the mid-20th century, it was definitely not anything now, right? Like the Commonwealth as a efficacious, if it ever was, political entity, a legal entity, was no more. And with PROMESA, the Congress sort of reasserted its colonial power in Puerto Rico. It installed a board that is still in place, much like the kind of board that was put into place in Detroit to oversee its financial. But this one has much more power and remains in place and will remain in place for the foreseeable future. I'm going to stop there. I would love to answer your questions. And yeah, that was a lot.